Fifth District Court of Appeals in Dallas, Texas is now in session. Justice Carlisle presiding.
Good morning. Welcome to the virtual Fifth Court. We've found these Zoom arguments to be productive and generally pretty smooth. If there's an issue, let us know, please. And if it turns out you're bandwidth it and supporting that video, feel free to downshift and come to audio only. That's really all we care about. No offense to either one of you's looks. We've got the case of Paniagua et al. Versus Weekley Homes. That's 0519439CV. We'll have 20 minutes aside, 5 for rebuttal for the appellant. With that, Mr. Horning, are you ready to proceed?
Yes, Justice Carlisle.
All right, here we go.
Good morning, Justices Carlisle, Mulberg, and Browning. Paul Horning on behalf of the Paniagua family. This is a case that involves the death of Mr. Paniagua back in May 31st of 2016, or March 31st, 2016, and was it's an electrocution case, Justices. It involved the building of a townhome in the Dallas area, just north of downtown. I think it's generally referred to as the Uptown area, and it was a relatively small townhome complex that was being built on Evening Star Way. The project was, and there's a dispute about who owned the land as far as the trial court evidence and record is concerned, but the general notion was that David Weekley Homes was going to own this land and build these townhomes using its employee by the name of Mr. Holmes, Holmes, who's widely cited to in the record as being what they call a builder. And Mr. Holmes testified, and this was presented to the trial court, that as a builder, he would go about and getting the labor necessary to build the subject townhomes, and that this particular project, the Evening Star project, or the villas at Kimsey Park, as it's also referred to, was behind schedule because they were having difficulty in getting a sufficient number of workers there to complete the project. And the reason that was important, Your Honors, as it pertains to the facts of the case that were shown to the trial court were that the contractor, in this case, Leobardo Mar, was unable to come to this particular project and do his work without first getting certain pieces of equipment that were being promulgated or mandated by David Weekley Homes. Specifically, the testimony in the trial court was that Mr. Holmes was not in agreement with and contested the use of wood or job site scaffolding to be used on the jobs that had previously been done for David Weekley Homes, but that in this particular case, the framing crew that the deceased, Mr. Maravilla, was part of, would have to obtain metal scaffolding, and particularly aluminum 48-foot sections of aluminum scaffolding for which Leobardo Maravilla had no possible way of affording or purchasing. As it turns out, David Weekley Homes has a program called TAP, which is a Trade Assistance Program, in order to fund or front money to its contractors so that they can complete what in some cases is very hazardous and dangerous construction effort. In this particular case, the TAP program was utilized by Mr. Holmes and David Weekley Homes, the appellee, to provide the metal scaffolding that was to be used in this particular case. It's been described as an advance to Mr. Leobardo Maravilla, but as it turns out, after this deadly accident, David Weekley Homes kept the scaffolding. So I don't believe it was an advance, and I believe the evidence supports the notion that it was, in fact, David Weekley scaffolding. That's the argument that was made at the trial court.
Mr. Horning, how do you relate these facts to the particular issues that are before us today? What's the significance of that backstory there?
With all that evidence, including the evidence that the David Weekley manager, John Holmes, instructed and ordered this crew to continue working, even though there were rain clouds and thunderstorms and lightning in the area in the late afternoon of the day. And the accident happened, the electrocution happened at about 5:30. That despite all of that evidence, the trial court granted a summary judgment under Chapter 95 that had been filed by David Weekley Holmes. We had filed, and that was originally in the 116th Judicial District Court, where that summary judgment was granted. After that summary judgment was granted, there was a order of an order to equalize caseloads, where the 116th transferred the case to the 298th, which ultimately is the court that denied the motion to reconsider the summary judgment. And that's why we come to the court today, Your Honors, to point out that the granting of the summary judgment under Chapter 95 was against the great weight of the competent summary judgment evidence that it presented, and in fact, it was reversible error. There were.
Can you describe the evidence of the storms? You mentioned those storms, and I've seen that in the record.
Yes.
In what way was that before the 116?
In the motion to reconsider, Judge, and that Justice Carlisle, forgive me, that is a very good question. The case has been transferred to the 298th to equalize the caseload. So the motion to reconsider was filed. It was filed February 15th of 2019, and by that time, Justice Carlisle, it was in the 298th Judicial District Court, and that was filed February 15th, and it included the report of an expert that was actually hired not by the plaintiffs, but was hired by one of the electrical provider defendants who were in the lawsuit originally. By the name of Mr. Longway, and his report was attached and provided to the 298 court, and it lays out all, and this is a trial record or clerk's record, and it goes from clerk's record 859 through 863, specifically the mention, Justice Carlisle, about the storms is on clerk's record 861, where the expert discusses the not only cloud to ground lightning strikes, but also cloud to cloud strikes. And from the report, it appears that patently on the face of the report that a certain lightning verification report called StrikeNet was employed to get the exact lightning count that was in that particular area between 5:15 p.m. and 5:37 p.m. Encore Electric Delivery prepared a lightning study for that same day, May 31st, 2016, which was the date of the accident. I apologize. And from that, the expert Longway, that's part of it, concluded that there was in fact a lightning storm going on. The testimony from Mr. Leobardo Maravilla was that before John Holmes, the employee from Weekley Homes, had left, he instructed him 5 or 6 times to continue working. In fact, to unload, these workers had loaded up their van, they were fixing to leave, and the David Weekley Homes construction manager, Mr. Holmes, instructed them to unload the truck, get back out there and finish the work, because A, it's about to rain, or it's starting to rain, and B, we have a City of Dallas inspector coming in next morning, and we need a green tag on this because we're already behind schedule.
So that counsel, the answer that you provided to Justice Carlisle regarding the lightning strike, this is evidence that was brought up after the summary judgment had been granted, and was part of a motion for leave to late designate expert testimony that was denied. And this was regarding a theory of the case that was, if I'm correct in understanding the record, different from the theory that was initially advanced in the case. Is that correct?
That is correct, Justice Browning. And if I may address that, there was several. Okay, well, first of all, the facts of the death of how Mr. Maravilla actually died were not crystal clear immediately. There was some testimony and thought and photographs that were done immediately after the death of the temporary power pole, which is a wooden pole that is used to deliver power on a temporary basis for construction. So there was a lot of effort and focus on that. Then OSHA got involved, and once we got the OSHA report, there was a great emphasis put on this electrocution happening because of the 48-foot aluminum pole that was being moved at the time of the electrocution, being either in contact or very close to a high power line that runs down the alley where, or near the alley where this electrocution took place. And in fact, in the OSHA report, there's some photographs that show the aluminum pole being, within feet of the power line. So for probably approximately about a year, that's what looked like to be the cause of this particular event. Now, what happened eventually, expert Longway was retained, and an effort was made to de-energize the whole neighborhood power system, so that the particular line that we initially thought was the source of the electricity could be removed. And there was approximately 109 feet of high tension cabling that had to be removed and taken to Mr. Longway's laboratory. It wasn't until then that Mr. Longway physically, and with the aid of expensive, very technical scientific equipment, was able to inspect clearly that power line and found no signs of any aluminum to power line activity. Also, he was able to get the reports from Encore and the electrical distribution people that noted that there was no tripping or upset of a breaker or anything like that that caused that would indicate to be the electrical source being power lines. That all came, Justice, after the summary judgment was granted. At the time the summary judgment was granted in 2018, that evidence had not been adduced, largely in part because of the unavailability of it. To wit, the power, that 109 feet of residential power line that had to be physically removed and replaced, and as one can imagine, that was no small undertaking, which Encore was able to take. And from that effectively ruled out the first two theories of the source of the electricity, and is only left with the electrocution. And that's why that was the genesis of our designation of that expert, and also the motion to reconsider based upon the newfound and discovered evidence.
So is the appellate issue that the trial court was wrong to deny the motion to reconsider, or is it the initial denial, or both?
Well, Justice Carlisle, it would be both. However, by virtue of the discovery of the evidence from the expert Longway that happened in December and January, December of 18 and January of 19, that evidence only supports a theory of negligence that the electricity came from thunderstorms and lightning, and not from a terrestrial source. So because of that, Justice, with all candor, we're not going to argue that the temporary power line or contact with the electrical wiring was the source of the electricity, because the facts are laid very bare by the expert Longway, where he says there's just physically, it's undisputed that the power line had nothing to do with it, but instead it had to have been the only other source for that kind of electricity. And also the expert looked at the autopsy report of the deceased, and everything points to it being lightning or thunder. And that was first addressed by the trial court's Justice Carlisle in the motion to reconsider that we attached as Exhibit 8 to the response.
Counsel, the cases that you rely on for the proposition that Chapter 95 doesn't apply to a general contractor all involve general contractors who are not or were not also property owners. Can you point us to any authority involving general contractors who, as the record seems to indicate, are also the property owners of the premises in question.
Well, there's, of course, there's the Ineos and our Baca cases that are cited by both sides for the proposition that a general contractor can be also a property owner. And in this particular, but like in Ineos, an employee was one of the defendants. And in this case, the only defendant employee of the general contractor, which is David Weekley Homes or Weekley Homes, would be Mr. Holmes, who we did not sue directly. So we would not, we only sued Weekley. We didn't sue one of their employees. So in this case, we would argue, and to answer your directly question, Justice Browning, there is no case that particularly says you have to be both an owner as well as a general contractor that I've discovered, that we've been able to find in our discovery and research for Chapter 95. And because of that, we believe that the Chapter 95 summary judgment would not be appropriate when, as in this case, we have alleged that the Mr. Holmes, the employee of David Weekley Homes, was in fact the one who commanded, and in fact, the testimony from the fact testimony that was presented to the trial court was that he commanded the work to be done in the weather that was presented that afternoon.
Well, counsel, that leads to my next question. If we accept your premise that Chapter 95 doesn't apply, what are you relying on in terms of from the record, in terms of anything that demonstrates a material fact that shows, Weekley Homes being on actual notice, having actual knowledge? I think, there seem to be some contraindications in the record.
The actual knowledge, Justice Browning, if Chapter 95 applies, there of course is the exception under 95.003, actual knowledge. There is the testimony of the Mr. Leobardo Maravilla testified, and this was questions coming from the defense, not from myself, where he was pointedly asked if he, how it is he blames the general contractor, David Weekley Homes, for causing this. And he points out, and this was cited in the motion to reconsider, and it's also cited in our brief, he specifically says, as we were leaving that afternoon, John Holmes came out and told us to stop, unload the van, and continue working for two reasons. Number one, so that rain would not get into the inside the house, because these are framers. They're creating the exterior sheeting of these townhomes. And there were apparently, when they were planning on leaving at 4:30 because of the oncoming storm, they were going to leave holes open. So the David Weekley Homes wanted there not to be holes for this storm. And the testimony was, and this is from Leobardo Maravilla, that John Holmes told us, and went so far as to say, Mr. Holmes went so far to implicate his own boss, Mr. Gerlinger from Weekley Homes, telling him to make sure that these holes and everything are covered up before the storm gets here. All right, and that's number one. And number two, Mr. Leobardo Maravilla testified that Weekley Homes wanted this work to be done before the following day because there was a City of Dallas inspector coming out to green tag the home, and they were already behind schedule, like I discussed earlier. Those, justices, is concrete testimony that was not elicited from the plaintiffs. This was elicited by defense attorneys, and they did not, they did everything they possibly could to try to get around it, but nonetheless, and Mr. Leobardo Maravilla testified to that, and that was the fact issue quite clearly that a Dallas County jury could have heard and listened to find that there was actual knowledge as required under Chapter 95, if it does apply, that in fact, David Weekley Homes gave him the equipment, They fronted them the money, instructed them how to use it. There was testimony, in fact, that Mr. Holmes showed them how to move the scaffolding. It was during the moving of the scaffolding when the deceased was struck by the lightning. And not only that, that these gentlemen, this work crew, they had packed up and were fixing to leave that afternoon when David Weekley Holmes stopped them and said, no, you have to cover up these holes, and we got an inspector coming. And 30 minutes later, Mr. Paniagua was deceased. And clearly that's actual knowledge, Judge. And the trial court, the second trial court judge had it, but only in the context of a motion to reconsider because of the prior summary judgment had been granted several months earlier. It was on, that evidence had not been adduced at that time as far as the no contact of the electrical line. And that was through no fault of the plaintiffs. So we would ask that the court decide that the appellant's case has raised a genuine issue of material fact, and that the granting the summary judgment did cause harm. Thank you.
Thank you. Mr. Nobles?
Thank you, Justice Carlisle, and I hope everyone is well. This case is somewhat procedurally different than most summary judgment cases because of the focus on the motion for reconsideration that was denied by Judge Tobolowsky after the case was transferred to her court. I understand appellate's counsel to be saying that the theories that the summary judgment were tried on are no longer really the theories that they believe in. That instead of their original allegation that there were T-poles, temporary electrical power supplies on the property that caused the injury, that's no longer their operative theory. That their new theory is that it was a thunderstorm. So I'm going to address the summary judgment arguments as well as the reconsideration. And if the court wants me to focus on one or the other, I'm happy to do that. The first point I want to make is, well, first that Judge Parker did not err in granting summary judgment, and Judge Tobolowsky did not err in denying a motion to reconsider based on new theories and new experts, which is an abuse of discretion standard, and there is no abuse of discretion standard, abuse of discretion shown in this case. The facts are necessarily speculative, I think, because of the circumstances. The most important issue in this case is the law, which is CPRC 95.003. And Justice Browning's questions, I think, address the elements of that statute. A property owner isn't liable unless it exercises some control over the manner in which work is performed. And Texas precedent establishes that that control must relate to the injury that the alleged negligence caused. The second exception that has to be shown by the plaintiff in order to escape summary judgment is in the last part of the statute. And these are conjunctive. It's not one or the other. The plaintiff has the burden to prove not only that the property owner controlled the details and the manner in which the work was performed, and that particular control caused the particular injury that was caused. The plaintiff also has to prove, this is conjunctive, that the property owner had actual knowledge of the danger or the condition resulting in the injury and failed to warn the plaintiff of that danger or condition. What we're talking about now are two different alleged causes, and it's difficult. It certainly is tragic. There are two alleged causes. One are the T-pole, the use of the temporary power supplies. That was what Judge Parker heard when she denied or granted the summary judgment, versus the idea that a thunderstorm and lightning caused it, which is what experts were saying after the summary judgment was granted. And based on that new expert witnesses and those new theories, Judge Tobolowsky exercised her discretion to say that it's too late. She didn't spell out the factors that caused her to lead to that conclusion, but it could have been any number of factors. It might have been a failure of the plaintiffs to show that they weren't, the plaintiffs, a failure in court, not out in the world, but a failure in court to show that this evidence couldn't have been developed in time for the summary judgment motion. There are all kinds of reasons Judge Tobolowsky might have reached that result. There's no reporter's record in this case. There's nothing that shows what she was thinking. Based on this record and based on the options available to her, it's very difficult to understand why, as a matter of law, Judge Tobolowsky had used her discretion in deciding that the summary judgment had already been decided based on different theories should be set aside and that it should all start over again. She certainly had the power to do that, but she didn't have facts and circumstances that compelled her to reach only that result. So the plaintiffs, I believe, today are arguing that Judge Tobolowsky had no discretion except to grant essentially a new trial and allow the summary judgment to be heard over again with new evidence, new motions, new hearing, and everything else. She didn't abuse her discretion in any respect with regard to that. I'd like to talk first about the statute. In turning to the statute, I'd like to talk first about the allegation that property owner status is disputed in this case. It's not. There are documents in the case, and I'll refer the court to specific record pages. It's in the first supplemental clerk's record, which has most of the summary judgment stuff in it. First supplemental clerk's record at page 729 and then at page 742 discussed the documentary evidence that Weekley Homes was the property owner of Lot 5A, which is the plaintiff's argument that the plaintiffs argue that the documents don't show that Lot 5A was owned by David Weekley. The documents show that it did, and those documents are at that page in the record that I cited to you. Certainly at the time of the accident, Weekley Homes was the property owner. John Holmes was an employee of Weekley Homes who was in charge of making sure that he had general supervisory control over the construction. His job was to make sure that the workplace was as safe as it could be, and his job was to make sure that the job got started and finished on time, I assume under budget or not massively above budget too. In order for there to be liability under section 95.003, the plaintiffs have to show that Mr. Holmes exercised such control over the details of their actions that it was his control that caused the specific injury caused by the alleged negligence. And their argument is that Mr. Holmes did numerous things that were in the nature of general supervisory control. He helped them procure better equipment, safer scaffolding to do the work with. He told them what the job timetable was so that they knew what they had to do each day. In this particular instance, Mr. Holmes was telling them that we have to finish this part of the project so that we can move on to the next part. Mr. Holmes is undisputed. Mr. Holmes left the project and left the subcontractor, not an employee of Weekley Homes, in charge of deciding whether to try to get the scaffolding moved that day or the next morning. And the testimony from the plaintiff's side is that Mr. Holmes didn't tell them they had to do it that day. They didn't have to do it in the rain. There certainly is evidence in the record that Mr. Holmes told them not to work in the rain. The plaintiff's depositions and the declarations of Mr. Holmes show that it was the subcontractor's decision to get this done today instead of tomorrow. And when his employees told him that we don't want to work in the rain, he's the one who decided that we have to work in the rain today. So on that score, there's no evidence in the summary judgment record that satisfies the level of control that has to be shown in order for Weekley Homes to be liable. Instead, the subcontractor was in charge of the details in the method of performance, its timing, whether the work had to be done in the rain or not. It certainly is in the real world a fact that an employee like Mr. Holmes might have said that we've got to stay on track and get this done, but he didn't. He was not on the premises when they moved the scaffolding. He did not tell them to work in the rain, and he did not have a level of control that's established that the plaintiff is required to establish under the first prong of the exception stated in 95.003. The second prong is also a problem for the plaintiffs that they did not overcome, and that is the actual knowledge requirement of 95.003. And the legislature passed section 95.003 and included the actual knowledge requirement because the legislature wanted to modify common law, which would have made a property owner liable to a business invitee for injuries that were caused by something that the property owner knew or should have known. And therefore, under the common law, there's a constructive knowledge or a duty to investigate that is much more related to factual disputes because it's a reasonableness question of what the contractor knew or should have known. But 95.003 changed the scienter that's required for the plaintiff to prove for a property owner to be liable. And it's now an actual knowledge requirement. And I think it's very difficult, if not impossible, in a case like this one, for the plaintiffs to have shown more than they did. And what they did show is not enough to show actual knowledge. And that is because the actual knowledge is a very specific requirement under the statute and the cases interpreting it. The property owner has to have actual knowledge of the danger or the condition that resulted in the injury and failed to warn of it. The plaintiffs have two different theories about what Weekley Homes should have had actual knowledge of. Their theory in summary judgment was that Weekley Homes should have had actual knowledge that there was something about the T-poles, we don't know what it was, that caused them to leak electricity into the ground, and that leakage of electricity on the wet ground is what caused the electrocution event. But there's no evidence that there was actual knowledge that those T-poles were leaking electrical current into the ground at the time that these individuals were moving the scaffolding. And that is what is required under the statute and under cases interpreting it, that Weekley Homes had to have actually known that there was a danger caused by leakage of electricity from those T-poles. And that there's no evidence of this. The summary judgment response filed by the plaintiffs in their brief picks it up, argues that there was constructive knowledge or should have been rather than actual knowledge. It doesn't refer to any evidence that shows that Weekley Homes or its employee, Mr. Holmes, had actual knowledge of this leakage of electrical current into the T-poles. That theory was abandoned by the plaintiffs in their motions to reconsider that Judge Tobolowsky heard, and to hear new experts who had a new theory, which is that a lightning storm sent a bolt of electricity that caused the electrocution event. And there is no evidence that Weekley Homes or Mr. Holmes had actual knowledge of a lightning storm at the time that this happened. And this kind of intersects with their control argument. But Weekley Homes wasn't there. There was no one there when the rain started. There was no one there to tell them from Weekley Homes that you have to get out of the thunderstorm. That wasn't the agreement that Weekley Homes reached with the contractor, the subcontractor rather. Weekley Homes didn't have the responsibility under that contract to be there to supervise the construction and to make sure that when a thunderstorm came up that people got out of the rain. There's no evidence that Weekley Homes knew that the thunderstorm was happening. There's no evidence that Weekley Homes was there and could have done anything to change what they did. There's no evidence at all. This wasn't developed as summary judgment evidence. It may have been a factor in Judge Tobolowsky's exercise of her discretion not to hear new expert testimony, but there is no testimony, no evidence that Weekley Homes had actual knowledge that lightning might strike these workers while they were moving scaffolding. And whether a jury would agree or not, at the summary judgment stage, there was no evidence in this case that Weekley Homes had the actual knowledge that's required. I'd like to cite to the court a case that was decided by this court in 2018. It's covered in the briefs. It's the Arana case, an opinion authored by Justice Lane Myers, involving very similar allegations, very similar summary judgment evidence, and the same result that happened in the trial court in this case, which is that summary judgment was granted on appeal. The Court of Appeals, Justice Lane Myers' opinion, the court held that there's no evidence of the level of control that's required, because in that case, as in this case, Weekley Homes didn't exercise control in a way that had a nexus to the alleged negligence or to the injuries that were caused by either the T-poles or the lightning storm. So Arana is the best case, I think, for the control issue in this case. And under Arana, it's governing precedent of this court that holds that under these facts or similar facts that there's no control that is necessary to be proved under 95.003. I think there's another issue that we haven't talked about today, and in the time I have left, I just want to mention it. There were arguments that the affidavits of, it's a declaration actually, the declaration of Mr. Holmes and of the general counsel for Weekley Homes, John Birchfield. There's an argument that the plaintiffs made that those declarations were conclusory and defective as a matter of substance that didn't have to be preserved. I think the best response to that argument is that those declarations state that the declarants had personal knowledge. Those declarations state facts that establish the basis of that personal knowledge. There's no magic language required for a declaration to show that it's based on personal knowledge. There's an argument the affidavits are conclusory, but a review of those declarations rather shows that they're not. And the final point, this is a point that our brief made, is that those objections, if they are valid at all, and we disagree that they are, there's no ruling on the objections to those declarations, because the argument is really an argument that there's a formal defect that has to be preserved in the trial court. It's not as though these declarations fail to say that they're based on personal knowledge. It's not as though these declarations fail to state facts that show that they're not conclusory, or that there are no facts supporting the personal knowledge of the declarant. These declarations are not like that. These are sufficient declarations that the plaintiffs had a right to object to in the trial court. They did, but they did not obtain a ruling from Judge Parker. And without a ruling, that is not reversible error. It certainly is not fundamental error. And it's not an issue that should slow this court down considering this case. And I would like to give back the time I have left. Thank you very much for your attention and for your courtesy in hearing us in this manner today. Thank y'all.
Thank you, Mr. Nobles. Mr. Horning, 5 minutes.
Yes, Justice. And going in reverse order, with respect to the objections to the affidavits, I would agree that there is no magic language that would create, that parties can use to create affidavits or declarations that are not conclusory or not based upon personal knowledge. But the case law does say you do have to state facts that show how it is somebody came to come across certain information and facts, and how they can possibly know what it is that they're declaring to. For example, John Holmes says that this property was owned by Weekley Homes, but nowhere in it does he state how he came by that information. Did he file the deed himself? You know, did somebody tell him? He just comes up with these conclusory statements, and there's 17 of them we objected to. And the objections are of substance; they're not of form. Now, with respect, though, and we believe that this court can consider those objections to the substance of those declarations, and certainly without the declarations, the summary judgment would not have been granted. Next, the court has asked about specific information, and counsel for Weekley Homes has argued that with respect to the second prong of 95.003, the actual knowledge requirement, that the plaintiff has not met the burden. Assuming arguendo that Chapter 95 does apply, I would point this court to the clerk's record. This is page 593, where the subcontractor, Mr. Leobardo Maravilla, is asked certain questions about why it was they were working in the rain. And this is the deposition that was presented to Judge Parker and Judge Tobolowski in the motion to reconsider. That is different from the Ariana case and other cases where you have admissions of actual knowledge by people present at the time. The question was put to Mr. Leobardo, and he is the foreman of this 3-person framing crew. That he was the one actually operating the forklift that was rented by David Weekley Homes when the deceased was electrocuted. Again, that's the reason. The forklift, the scaffolding, you can start to see that there's a trend here that Weekley Homes is providing all the equipment for these laborers. He is asked, this is a question directly put to the witness. Did John Holmes tell you to try to move aluminum scaffolding during the rain? Question mark. And this is page 30 of the deposition of Leobardo Maravilla at court record 594. Did John Holmes tell you to try to move this aluminum scaffolding during the rain? Answer, yes, because we had to finish the upper part of the front. Now, that page and the page before it, and then also our relevant justices, as well as the page on court record 620, also has questions and answers to Mr. Leobardo Maravilla, instructing him. And in fact, this is from the deposition on page 165 of Mr. Maravilla. He is asked, and that way you chose to move these scaffolds from one location to the other. Are you saying that that's John's idea too? Answer, yeah, it was his orders, by his orders. So that's the testimony, justices. In this case, David Weekley Homes had to get this project done. They didn't have the work crew to do it. They're running behind on time. The one work crew that they could find didn't have the forklift that was being used at the time of this electrocution. That same crew did not have the scaffolding. Undisputed that David Weekley Homes is the one that provided the scaffolding under this advanced program called TAP, Trade Assistance Program. You know, note that it's not Workman's Compensation Insurance Assistance Program. It's trade program, so that David Weekley Homes can get these laborers out there working and using the sophisticated aluminum scaffolding, as it turns out to be a rainstorm. And they'd also had an inspection coming the next morning. So quite clearly, both prongs of 195.003 have been met, where there was a not contractual control. It's undisputed that we're not talking contractual. We're talking actual control by David Weekley Homes of the means and methods, means, scaffolding, forklift, and method. You have to come back and unload your van at 4:30 in the afternoon and continue the work until the evening. You know, that's the method that was being instructed by Mr. Holmes from his boss at David Weekley Homes, all the way down to these workers, and then which subsequently was the direct and sole cause of the electrocution of Mr. Paniagua that resulted in his death in the subsequent lawsuit. All that information was presented to both trial judges. It's been argued to them as to why they made the rulings. We don't know, but in fact, it is against the great weight and degree of the credible summary judgment evidence.
Thank you very much. We appreciate your arguments today. We
Thank
will
you.
submit, we'll have an opinion for you in due course. The case is submitted. Have a good day.
Thank you very much. Thank you.